My name is Brian Young, Comprehensive Financial Planning Group. I'm right now located in the Hagerstown office, Hagerstown, Maryland, but we have access and offices in multiple states, everything from Wilmington, Delaware, Atlanta, Georgia, Burleson, Texas, and Elkhorn, Nebraska right now. So kind of getting spread out a little bit, but this is such an important need. Tonight, wanted to start out with, anytime we're talking about special needs planning, I think it's important that you understand who the presenters are and why we do what we do. So it's kind of our why statement. And for me, I joked with Megan when we were looking at this. This is my favorite slide in the entire presentation. But this is Max. And the reason I share this about my son, this was a picture taken when he was about 12 years old. He just turned 18 over the weekend. And, as a parent of a special needs child, after all, we named him Max. His official name's Maximus, and I got that from the movie Gladiator back in 2005 when he was born. My wife didn't like the idea of Maximus. I forget, Maximus Aurelius or something was the full name, but you have this vision of a kid running out onto a football field when he's in high school and everyone cheering his name, and that didn't happen. And but around that time when he was 12, as a parent, I started to recognize, we're going to be responsible as parents for Max to some degree the rest of his life. And I think my wife recognized it quicker than I did. Maybe as a guy, I find talking to fathers, maybe we hold on to it a little bit longer. We don't recognize it as quickly, or maybe we're in denial. And I see that. So I say that, and I want that to be important, because now, here I've been in the financial planning industry since the late 1990s. It was 1996 when I came into the business. And when he was 12, so 6 years ago, I then sat down and thought, the financial plan that I have been doing for my family was not going to work. And I say that because here I am, a CFP, Certified Financial Planner. And if you've ever worked with a financial planner, you think they might know how this works. But if I put all the study material for the CFP program on my desk, I'm not kidding when I say it's 18 inches high. And there were 2 paragraphs about special needs trust. So just the fact that working with a CFP, you would think they may know it, 2 paragraphs doesn't cut it. So it put me on a journey as a parent and as a financial planner. And I quickly realized, if it was this challenging for me as a planner and having the background access to resources, how difficult is it for folks that don't have the same access or background? So I share that, and we've come a long way in the last 6 years, to the point now where this is more than half of the new business and cases I'm working on, literally with planners in states all over the country. So I share that, and I think it's important now for Megan probably to give you a little bit of her background.
Yeah, thanks, Brian. Good evening, everyone. And thank you to all of the attendees for taking time out of your evening to join us tonight to talk about special needs planning. Again, my name is Megan Ingram. I'm one of the attorneys at the law firm of Steinbacher, Goodall, and Yurchek. Like Kyle said, I work out of our State College location, and I focus most of my practice on wealth protection planning and special needs planning. I have to say I am licensed to practice law in Pennsylvania, so all of the information I'm going to be discussing tonight is based on Pennsylvania law. So if anyone's joining us tonight who is not a Pennsylvania resident, first, we're so happy that you're here. But I do have to advise you to meet with an attorney who's licensed in your home state to see how you should be structuring your estate plan based on those laws. So I was fortunate to be named as a rising star attorney by Super Lawyers in 2022 and 2023. And I've also gone through some additional education and training to be a certified dementia practitioner to better assist our clients who are going through the dementia journey. I got my undergraduate degree and my law degree both from Penn State. You can't leave Happy Valley once you're there. And while I was in law school, I spent most of my time studying tax law. But like Brian, special needs planning is an incredibly personal matter to me.
It's always important that you guys know a little bit about us. So let's get into why do we plan? And Megan started to touch on this, and it's really important because as parents, when we're lying awake at night and there's a lot of questions that we start to ask, could your loved one with some type of special needs manage funds or need assistance? Well, generally they're going to need help, we know. Could their situation change over the years? Absolutely. So we have to have a plan that's going to be nimble enough to change with them. But other reasons why we think we need to start to plan: who's going to advocate for them? Who's going to protect them from abuse? It's not just physical abuse, but it's also financial abuse, and that's important too. It's one of those things that gets overlooked all the time. And then, there's government benefits that are available. Is it going to be advantageous for our loved one to be able to qualify for some type of government benefit, whether it's SSI, Medicaid? Do we understand how SSDI could eventually come into play? These are all important. One of those questions that comes up, and I have never met a parent that this probably should be at the top of the list. Who's going to take care of my loved one, my child, a sibling even, if I'm not around? I guarantee it's probably been on everyone's mind that's been on this call. So these are some of the questions. And again, those were just a couple of the questions. I could probably make so many more up, but where do you really start? So when it comes time to start and you look up and you're like, all right, what do we got to do? First and foremost, I think this has probably been one of the things in talking to parents over the last half a dozen years is the parent needs to recognize we need to prepare a plan that's going to endure the rest of our child's lifetime. That's super important. If you got a husband and wife or two parents and one of them's not on board, I will tell you the planning process is going to be difficult. If it's a single parent, we have to work with those dynamics as well. But if as the parent, we don't accept it, I will tell you there's no sense in really taking the next step. So when you start, you're going to start hearing a bunch of different terms. One thing I want to preface this with, and you're very fortunate tonight, you have Megan on here with her legal background as an attorney, and with me being a CFP and a charged special needs consultant. When you go down this road, so much of this is interwoven. It really is. And so you're going to find things that overlap so much with what the legal and the financial components are. But that's important because at the end of the day, when you're doing a plan, one of the questions that'll come up is, should I do my plan first and then do my kid's plan second, and then have that kind of updated, or vice versa? And in all honesty, they should be done at the same time. So one of the things that's going to come up, life care plan, letter of intent. Megan's going to talk a little bit about this later on. Who's going to act as a guardian or custodian? Again, this is one of those topics Megan's going to hit on. This one is a moving target. And we can get pretty creative with this, but again, we want to do what we can so that our child or our loved one has the opportunity to thrive in some type of environment. And we're going to hit on this as well. And again, this is where we get into the resources that are available from the government, what's available. So we'll hit on that a little bit. This is the financial side, and I love this. What is the most efficient way to pass assets to my child? I probably should put one word in there, and that's called, what is the most tax efficient way. I'm sure everyone enjoys writing checks to the United States Treasury, state of Pennsylvania, and so forth, depending on where you're at, or Maryland. Megan's going to get into a little bit about the different types of trust that we deal with in the special needs planning component. And again, this comes back into the ballpark of, once we know what types of trust we need or we got to implement, how do I fund these trusts? And it gets a little tricky. Rather than just saying, here, I'm going to have this trust and you have this money in a 401k, does that make the most sense? So we're going to talk, one of those things about it we'll talk about later is tax implications. And we're going to hit briefly on what is an able account. So you see these different scenarios here. These are all things we're going to touch on this evening, just as a little bit of an outline. We're going to give you an overview, and then Megan and I are going to kind of dig into these a little bit. Again, as much as we can in an hour and 20 minutes. So something that we're really looking at here is what I like to call multi-generational planning. Now think about this for a second. Most families that have, for lack of better terms, what we call them nowadays, neurotypical kids. And I don't know if any kids are neurotypical anymore. You know, there's always something going on. But for the lack of better terms, that's something that gets thrown around. That's a word. Most parents are focused on, all right, I have my working years. I need to focus on retirement. Maybe if it's a husband and wife, or, you know, two parents, I got to focus on survivorship needs. But then beyond that, in the normal circumstances, it's like, well, whatever's left over is going to end up going to the kids. There's blended families. You might have things go to church, charities, and so forth. But now, when we have that child with special needs, well, think about this. If you're right now 50 years of age and you're planning on your regular life, you know, you might have another 30, 40 years that you have to plan for, but you have a son or daughter who's 15, they could live another 60 or 70 years. So now the length of time your plan is going to be in place basically is almost doubled. So when we get into multi-generational planning, you know, if you don't have the ability as a planner, whether it's on the financial or legal side, just to look at what a husband and wife or a family needs now, you have to be able to look long beyond that. So this is one of those things I said just a little bit ago. Your plan needs to be completed and work in conjunction with your child's plan. Very important. Let me give you an example. If you're doing legal documents for yourself, wills, powers of attorney, trusts, living trust. But I had said earlier, my son just turned 18. And there's some other things there, and we're not really going to get into it tonight, but when an individual turns 18, the very first thing, the next day after his birthday, we get an email that says you can't act on his behalf at the medical facilities anymore. So now I've already got it set up. We're working on powers of attorney for our son. So he has to be able to say, I recognize that my parents are going to act on my behalf for financial and medical, and I'm elaborating a little bit, but it's a lot more dummied down than that, but it's super important. Flexibility and review of the plan is imperative as laws change. We see tax law change almost every other year, and sometimes every year, depending on what it is. And there's certain assets. I will give you an example. If you have a 401k and you have money go to just a child that has, you know, neurotypical, everything's fine, versus a child with special needs, that money goes 50-50. It gets treated differently for each child. So we need to know what's going to each one. And that's why in this next one, understanding what assets are going to pass to your child with special needs. And we have to be careful so that we do not adversely affect any of their government benefits if they're receiving them. Super important. And these things is what would get overlooked most of the time. What assets should fund a special needs trust? We're going to talk about that. So if you have assets that should go to a special needs trust, that means there should be a different assets that may be better to go to the child that doesn't have special needs. Super important. Disinheritance. Let's talk about that a little bit. And what that really means. I've seen before where parents will look up and say, I'm not going to leave anything to my child with special needs. I'm going to leave everything to their sibling. And the sibling's going to be responsible for the money so that, the one with special needs doesn't have to worry about it. So really, in essence, what you've done is you've disinherited the individual that in all actuality may need the money the most. Super important. Why could that be a problem? Well, let's say, and I'm going to just use an example here. I only have one child. His name's Max. And let's just paint a picture and say he had a sister, a fake sister by the name of Riley. And I left everything to his older sister, Riley. Well, Riley could end up getting married and then end up getting a divorce. And could you see where a lot of that money could be taken away in a divorce settlement? Or what if she is sued over a traffic accident? So disinheritance, as accidental as it could be, can be catastrophic in the overall planning. Now, understanding how life insurance can provide a benefit in your estate plan. Life insurance in Pennsylvania is probably one of the best assets that can be in a plan. And I'll just give you a couple points why. One, Pennsylvania, life insurance is exempt from the inheritance tax. So if anything's going to the kid at 4.5%, you don't have the Pennsylvania inheritance tax. Two, life insurance, when structured properly, is tax-free, the death benefit. So that can, a lot of times people look up and they're like, I don't really like life insurance, but there is a lot of benefits that can come from it. And then this last one, as it bounces into the screen, or tax implications. Let's just talk about that for a second. You have a 401k or some type of pre-tax plan with your employer. It's great, especially this year, you're starting to see some growth in it. But what ends up happening if that ends up going to your child with special needs? Just keep in mind, pre-tax money is nothing more than a deferred tax. Either you're going to pay tax on it while you're alive, your spouse, or when you pass away, whoever the beneficiaries are going to pay tax on it unless you have it going to a charity. So something to keep in mind. And that isn't just about the special needs planning component, but that's about your personal retirement and investment planning as well. So there's all this gets kind of thrown together. So with that being said, I kind of gave a little bit of an update there on the overall why you're planning, some things you're going to know about. But now I'd like to have Megan talk a little bit more specifically about some estate planning documents and some other things.
Great, thanks, Brian. Yeah, so I'm now going to walk us through what the attorney's legal aspect is going to be for the special needs planning part, which is a lot of paperwork and a lot of documents. And specifically tonight, I'm going to be talking through powers of attorney, last will and testaments, and trusts. Now, I'm going to kind of go pretty briefly through powers of attorney and last will and testaments so we can spend most of our time talking about trusts. But I would be pretty remiss if I didn't spend at least some time talking about powers of attorney. Without a doubt, powers of attorney are the most important estate planning document anyone can have. At its core, what a power of attorney is it is just a written document where you are naming someone else who's allowed to make decisions for you and act on your behalf. That's really all it is. And at our firm, Steinbacher, Goodall, and Yurchek, we actually have 4 different kinds of power of attorney documents that cover 4 different areas of decision making. So of course, the first up, we have a financial power of attorney. That document says who's allowed to manage my money and my assets for me, who can pay my bills for me and go to the bank and file my taxes and do all that fun stuff for me. A healthcare power of attorney says who's allowed to talk to my doctor and make medical decisions for me. That healthcare power of attorney is a really general document that we're going to pull out anytime you need someone to make medical decisions on your behalf. On the other hand, the next document we have here, the living will, that's a much more narrow document that covers medical decision making. The living will is sometimes referred to as an end of life document. The living will is the document that says, heaven forbid, if I am ever permanently unconscious and there's no hope that I'm going to recover, what kind of life support provisions do I want? Do I want a ventilator, a feeding tube, and all of those life prolonging measures, or do I just want to be kept comfortable and let me pass away naturally? That's what's covered in the living will. And the last power of attorney that we have at our office is a mental health power of attorney. The mental health POA covers a lot more, and it gives your decision maker a lot of power to make much more kinds of decisions in the realm of mental health treatment. It covers a lot more than what's just covered under that general healthcare power of attorney. And that's because there's some really specific laws in Pennsylvania governing mental health decision making. So, as Brian, already touched on what he's going through with his son, Max, these powers of attorney, these are documents that all of you as parents, we're going to be recommending to you for your estate plan. But really, anyone who's over the age of 18 should also have powers of attorney. So as Brian already said, once your child turns 18, even if you've been able to act on your child's behalf and make all kinds of decisions for them financially, medically, while they were a minor, once they reach that magic age of 18, they are now a legal adult, and you don't necessarily have all of the same abilities and powers to continue to make decisions for your child and act on their behalf. So while these powers of attorney are really necessary for you, we're also going to be talking about, like Brian is, we're also going to be talking about having your child possibly sign powers of attorney once they turn 18 that name you as their authorized decision maker, so you can keep acting for them. Now, anytime someone is signing a power of attorney, one of the things we always need to focus on and think about is whether the person signing the document has the mental capacity that the law requires for them to sign a legal document. The law says in order for someone to sign an effective power of attorney, they have to generally understand the document, understand what it says and what it does. And I will say the person signing it does not need to understand every word of the document. I usually joke that I had to go to law school for 3 years before I understood every word of the document. But the person signing it just needs to generally understand that whenever I sign this, my parents are going to be able to talk to my doctor and make medical decisions for me, or they can go to the bank and manage my money for me. Now, sometimes, occasionally we are working with families where an individual, a child, does not have that level of understanding that they need to sign a power of attorney. If that's the case, if your child would not be able to sign a power of attorney, that's not the end of the road. We can always try to get a guardianship as an alternative method to allow you to keep making decisions on behalf of your child. What that guardianship process looks like, it's this process that we have to go to court for. So we would have to go through the court system, and we have to present evidence to a judge that the individual is not able to make his or her own decisions. They're not able to manage their own finances. They're not able to really think through and make their own medical decisions. Once the judge hears all the evidence that we present to them, it usually requires a doctor testifying in some way. Once the judge weighs all of that evidence, if they agree and think that someone else should be assisting this individual with making decisions, then the judge appoints someone to be the guardian over that individual. So this would be where you would be appointed as a guardian of your child if the judge found that was necessary. Now, when we're thinking about different options for decision making for your child, we always prefer to do powers of attorney if we're able to before we go the guardianship route. And this is actually preferred under Pennsylvania law. Pennsylvania law wants us to try to get powers of attorney signed before we get a guardianship. And that's really because, thinking about what happens legally in each process. When someone signs a power of attorney document, the person signing that document is not giving up their own rights to keep making decisions for themselves. They can sign a power of attorney and they can continue to pay their own bills, manage their own finances. That power of attorney just names someone else who is also able to go to the bank and is also able to manage the money. On the other hand, with a guardianship, if a judge decides that a person needs a guardian appointed to make decisions for them, once that guardian is appointed, that individual no longer has the legal ability to make his or her own decisions. And so because that guardianship process really takes away so much of that individual's personal decision-making capacity and autonomy, we always want to try to get powers of attorney signed before we think it's necessary to go the guardianship route. Also, a guardianship just takes a whole lot longer since it has to go through the court system. Usually takes about 3 months on average to obtain a guardianship. But that's usually our different routes for ensuring that you're still able to make decisions and take care of your child into their adulthood. So after powers of attorney, another estate planning document that we're going to want to make sure is included in your plan, of course, is a last will and testament. Now, many of you on here are probably familiar with wills. This is the document that takes effect when you pass away. And this document says, when I die, where's all my money and my assets going to go? Who's going to get what when I pass away? The will also appoints someone as your executor or your personal representative. This is where you are choosing the point person who's going to make sure everyone gets what they're supposed to be getting, and all of the inheritance taxes are filed and all that fun stuff. And if you have any kids under the age of 18, your last will and testament can also name who's going to be the guardian for your minor children, who's going to take custody of them and raise those kids after you pass away if they're still minors. And the last thing we're going to want to make sure is included in a last will and testament is if any of the beneficiaries you're including in your will are minors, they're under the age of 25, the age cutoff is a little bit different for this part. If anyone's under the age of 25, we're going to want to appoint a custodian who is going to manage that inheritance and that money for that beneficiary until they turn 25. And really, with this area of estate planning, a big thing that we think about with special needs planning is what is going to happen if your child who has a disability or special needs comes into a lot of money. You know, a lot of times I have clients who come in and say, well, my child doesn't have any money, so we don't really need to worry about planning for that. But really we do. And this is, you know, where we're going to be thinking about all the different options where your child could receive a large amount of money. For example, what if you want to leave them something when you pass away? You know, as Brian said, one of the main reasons why we're here tonight, and I'm sure what is driving all of you to RSVP and attend this seminar, is you want to make sure that your child is supported and has the resources to take care of them after you pass away. So what's going to happen once they receive that inheritance from you? Or another situation that we've seen, what if someone becomes disabled? What if they go through a personal injury lawsuit and then suddenly they have a cash settlement that they've received from this lawsuit? Or maybe your child could hit the lottery. Maybe they have a fantastic weekend at the casino and they come away with a lot of money in their pocket. Or another option is what happens if they get married? You know, what if they get married and then suddenly their spouse has some assets that could be commingled and be considered their own assets? What do we do then? On the legal end of things, the things that we're going to be thinking about with that situation is this individual receiving any public benefits now? Or could they possibly qualify for and receive public benefits in the future? And once they receive all this money, this inheritance or this settlement, once they receive that, are they now going to have too much money to still qualify for their public benefits? You know, Brian's going to go through a pretty brief overview of the different public benefits programs out there. And as you're going to see, even just through that brief overview, it's really strict eligibility criteria for each of these programs. And so we really want to make sure that your child is not going to be losing any kind of public benefits that they might be receiving by receiving too many assets in the form of an inheritance or another means. So if someone does have a disability and they're going to be receiving a lot of assets, the good news is we do have a couple tools in our toolbox that we can use to make sure we can structure these assets and set it up in a way that they can still benefit from this money that they're getting while still maintaining their eligibility for government benefits. And the different tools that we have available to us are special needs trusts, able accounts, or if it's a relatively small amount of money, maybe they didn't hit it that big at the casino last weekend, that might make the most sense just to figure out that we're going to spend down this money in the month that we receive it to bring their assets back down to the level where they still qualify for their benefits. But ultimately, at the special needs planning level where Brian or I are getting involved, we're looking at larger sums of money, typically an inheritance from a parent or other family member. And we're going to be looking at, should we be setting up a special needs trust or an able account or both? So I'm going to go through special needs trusts very briefly, and then Brian's going to go through able accounts later on this evening. But let's start with special needs trusts. So trusts are a very specific and very unique tool in estate planning law. Trust is really what it is. The trust is a separate legal entity. It's separate from yourself, separate from your child who has a disability. It's a separate legal entity that is allowed to own property. And the trust document that you would sign with your attorney's office, that document is just the written set of rules that says what can and cannot be done with the assets that the trust owns. That's a very, very watered down description of trust. And a special needs trust is really just a very specific kind of trust that we're going to be using anytime the beneficiary of the trust has a disability or special needs. Some of the people involved in the special needs trust, of course, we're going to have a trustee. The trustee is the person who's responsible for managing the money or the assets that the trust owns. And then, of course, we have a beneficiary of the trust. Who's the person who's going to be allowed to enjoy and benefit from the money that the trust owns? The special needs trust is designed particularly so that it's a mechanism that we can use to leave money, leave resources available for an individual who has a disability, set them aside for that person without jeopardizing their eligibility for public benefits. And the special needs trust is going to have really strict and particular rules in it that says the money in the trust, it has to be spent in a way that benefits the beneficiary and makes their life better. But it also can't be spent in any way that's going to jeopardize their eligibility for government benefits. And how strict those rules are really depends on what kind of public benefits the beneficiary might be getting. So really, that's the general overview of special needs trust. And there are 3 different kinds of special needs trust that we're going to be talking about tonight. We have first-party trust, third-party trust, and pooled trust. So I'll get started by talking about first-party trust. This slide really gives a lot of information, gives all the information that you might need to know about a first-party trust. But I'm going to just hit the highlights for the sake of our time here tonight. So with a first-party trust, what the distinguishing factor is that makes it a first-party trust is the money that we are going to be putting into the trust is the money of the individual who has special needs. That individual has too much money of their own, and they're going to lose their government benefits. So they set up the trust themselves, and they put their own money into the trust. The classic example that we see where we use a first-party special needs trust is where a parent passes away and a child is going to be receiving an inheritance from mom or dad's estate, and that child has a disability or special needs. And they come into our office and say, I'm getting this inheritance from my mom or dad soon, and I'm afraid I'm going to lose my benefits. I'm going to have too much money to continue to qualify. What do I do? So the first party special needs trust is a way that they can take that money once they get that check written out to them. They set up a trust themselves and they put their own money into this trust. They set it aside so it's out of their name and they can continue to receive their public benefits while still being able to benefit from and enjoy the money in the trust. The big thing about a first party special needs trust, though, that we always are concerned about is something called a payback provision. What this payback provision does is this says that if someone sets up a special needs trust for themselves and they put their own money into the trust, then whenever they pass away, if there's any money left over in this trust that wasn't spent or used on their behalf during their lifetime, then if they receive Medicaid benefits during their life, the state gets first dibs at the money left over in the trust. The state will want to reimburse itself for the money it spent on that individual's Medicaid expenses during that person's life. So first party special needs trust is a really great tool we have sort of whenever it's too late, when the money is already on its way to the individual who has a disability or special needs. It's a way that we can kind of shelter that money to keep it qualified. But overall, the much better strategy that we're going to prefer is to have folks plan ahead and do the third party supplemental needs trust. This third party supplemental needs trust, it's still going to have a beneficiary. The beneficiary is still going to be the individual who has a disability. But with a third party supplemental needs trust, the individual who has special needs, they're not the one setting up the trust. They're not the one putting their own money into the trust. Instead, someone else is setting up the third party supplemental needs trust on behalf of the individual. And someone else is putting their money into the third party supplemental needs trust for the benefit of the individual. So again, classic example is a parent comes into our office and says, I have a child who has a disability and we want to make sure that they can receive an inheritance in a way that's not going to jeopardize their benefit. So the best strategy there is for the parent to set up the third party special needs trust. And then we structure your assets, we set up your will, and Brian works on setting up all the beneficiaries of your non-probate assets to make sure when you pass away, we're not going to give the assets directly to your child who has a disability. We're going to make sure everything is funneled directly into this third party special needs trust that you set up for your child. And the good news here is because the money's not going into your child's hands, it's going directly into this trust that you set up. With a third party special needs trust, we don't need to include that payback provision. So that means if whenever your child who has a disability, when they pass away, if there's any money left over in this trust that wasn't spent or used during their lifetime, you get to say who gets it next. The state can't get that after them. So for that reason, it's really important that we do this kind of planning ahead of time to make sure that if you have a child who you want to leave an inheritance to, we want to set it up so it's flowing into a third party special needs trust instead of trying to fix things and structure everything after the fact by having your child have to do that planning themselves. And finally, the third kind of special needs trust that's out there is a pooled trust. In a pooled trust, really the distinguishing factor for this kind of trust is where the trustee, the person managing the money and the assets in the trust, the trustee of a pooled trust is a nonprofit agency or a professional trustee like a bank or a financial institution. So instead of appointing, a family member or a friend as a trustee, we're going to go with a professional decision maker, a professional trustee to manage that money. Oftentimes with a pooled trust, then that professional trustee is going to pool all the resources from all the special needs trusts they manage, and they're going to invest it all as a sum. That's what makes it a pooled trust. So after we know the kind of trust that we're going to be working with, the next big question we have is who's going to be the trustee? We know the kind of trust we need to use. We obviously know who the beneficiary is going to be, but who's going to be the trustee? Who's going to be the one managing the money and the assets in this trust? And who's going to be responsible for spending it in appropriate ways? Some different options, obviously, a family member, maybe you have multiple kids and you want, one of your other children to be the trustee and manage that money for your other child. Maybe you have a friend or someone else you have a personal connection with who would be a good option for this. Or maybe you're going to go, like I just mentioned, with a professional trustee, like a nonprofit organization or a bank or financial institution to be the trustee to manage that. I always like to note that if you choose to go with a professional trustee, something that we always think about is, do we want to incorporate into the trust another group of people that we call a trust committee? So, one of the concerns that a lot of folks have with using a bank or financial institution as the trustee is, do they really know my child? Do they know what my child likes to do? Do they really know the best ways to spend the money in this trust to benefit my child? But if you decide to go with a bank, if that's the best choice for your child and for your family, we can include a trust committee. It's a group of people who knows your child, can be family members, can be friends, and we can really structure what their roles are going to be in the trust just to make sure that they can still be involved and make sure that the trustee and everyone is really acting in the best interest of your child and make sure everything is going as best as it can for your child. So when we think about, who we're going to be appointing as trustee, another big thing we want to think about is, what is the trustee going to be responsible with doing? What are the responsibilities of the trustee? So as I said, the trustee is going to be the one managing the assets and the money that the trust owns. They're going to be responsible for making sure everything is invested. They decide how it's invested. They decide how the money in the trust is going to be spent. So of course, all the money in the trust has to be spent in a way that's going to benefit the beneficiary. But if the beneficiary wants any money or wants anything from the trust, they have to go to the trustee, and the trustee is the one who holds the purse strings and decides when we're going to spend the money in the trust. So another big thing we want to think about with the responsibilities of the trustee is, the trustee should really understand the different public benefits programs that the beneficiary is on or could qualify for, because they need to understand that if I spend money on this particular thing, for example, if the beneficiary is on SSI, if I use the money in this trust to help pay that person's rent, is it going to impact their SSI check that they get? The trustee needs to know how it's going to impact their public benefits. Finally, the trustee also needs to make sure that all the taxes are filed and paid for the assets in the trust. The trustee also has a lot of fiduciary duties that they owe to the beneficiary. The biggest one is the trustee has to be loyal to the beneficiary. When the trustee is making decisions for what's going to happen with the trust assets, the main thing that they have to be focusing on in making those decisions is what is in the best interest of the beneficiary. They can't be thinking about themselves. They have to be focusing on what's best for the beneficiary. The trustee also has to keep trust assets separate from their own personal assets. They can't just put everything in their own bank account and manage it all there. They have to keep it separate. The trustee has to make sure that any money or assets in the trust are invested prudently. So any investments they make have to seem wise or seem like a good idea at the time that they do it. They also have to make sure that they are following all of the terms and rules that are outlined in the trust document. So like I said, the trust document that you would sign with our office outlines all the rules of what can and cannot be done with the money in the trust. Trustee needs to keep track of all of that and make sure they are following all the rules. And the trustee needs to keep really detailed records of everything they do, every dime they spend of the trust money, so they can show exactly what they've done and why they've done it if they ever need to. So keeping all of that in mind, what the trustee has to do, what should you be thinking about when you're choosing someone to be a trustee? I think the biggest thing to be thinking about is, does the person you're thinking of appointing, do they understand the different public benefits programs out there? Do they understand the programs that your child is on? Do they understand how spending the money in the trust could possibly impact those benefits? And even if they don't understand those public benefits programs now, are they going to be willing to put in the time to learn about it? That's the biggest thing. They need to know how the money in the trust could possibly impact the beneficiary. And so being a trustee of a special needs trust takes a whole lot of time. It takes a lot of time commitment to make sure everything is, sorry, Brian, could you go back one more?
Oh, sorry.
They need to make sure that they have enough time to spend all the money and make sure the beneficiary has everything that they need from the trust. Now, the thing to think about is, what are the fees going to be? If you're choosing a professional decision maker, like a bank or a nonprofit agency, they're probably going to be taking a fee for their service to be the trustee. Family member or a friend, they have the right to take a fee for being a trustee, but we usually don't see them taking one. And finally, of course, the biggest question that probably should have been listed first here is, does that trustee, are they familiar with your child? Do they know what your child likes to do, what they don't like to do? And are they really going to know the best way to spend the money in this trust to really enhance your child's quality of life in the best way possible? So, but one of the things is, if you're thinking about appointing someone who might not be super familiar with your child, for example, if you're looking at a nonprofit agency or a bank as the trustee, and you want to appoint someone like that, a professional, because of their vast knowledge of all the public benefits programs and investment background. Even if you choose someone who might not know your child that well, we can still give them the information they need to know the best ways to spend that money on behalf of your child. So for example, at our office, we could put together what's called a summary of our wishes. Brian kind of mentioned this before. Some other offices call this a letter of intent or a life care plan. We call it a summary of our wishes. This is actually not a legal document, but it's really just a manual of everything and anything you might need to know about your child. So this would tell whoever's involved, who are the people involved in your child's life, who are their physicians, any guardians, what kind of medications are they on, what pharmacy do you use? This also tells them a lot about your child and what they like to do. What are their hobbies? Do they really like video games? Do they really like going to the movies? Do they like to go somewhere on vacation once a year? What kind of foods do they like? This is where you can really lay down everything that the trustee might need to know so they know the best way to spend this money that you've set aside to benefit your child. So now that we've done a whirlwind overview of estate planning documents, I'm going to pass it over to Brian to talk really about how to fund these trusts, because, we would give you, really great trust. And it's important that you have really good documents. But the second part of that is the funding. It doesn't matter how good the documents are if the funding isn't there and if the assets aren't set up correctly. And that's why we're so happy to have Brian on tonight to cover that portion of it, which is just so incredibly important. So I'll hand it back over to you, Brian.
Thanks, Megan. One of the things before I go to the next slide is, I was sitting here listening to you give the overview of the different types of trust, the first party, the third party, the pooled trust. And it's so important, and I'm sure Megan has seen this, time and time again. When parents get the trust set up, especially if they did something many years ago, it kind of gets lost in, oh, I just know that I set up a special needs trust for my son or daughter. And the reason I say this, it's so important to review with a professional if you haven't visited it in a while. And I want to give you an example why. About 3 years ago, some clients of mine, they were new clients, and they said, hey, we have a daughter, special needs, kind of going through the whole system. We already have a special needs trust set up for her. And at that point in time, they were leaving a significant sum of money. It was several $100,000 that was going to go into this special needs trust for their daughter. And they thought that they were doing a wonderful job. Well, once I got into really picking apart what they have and explaining it, they actually had what was called the first party special needs trust. And just to kind of recap there, what Megan was hitting on, the first party special needs trust, there's one key provision in there, and that has that payback or clawback provision. To, each state calls it a little something different. But the point is, here's a husband and wife. They're almost 80 years of age at this point. Their daughter was in her late 50s. And they were going to leave a couple $100,000 to her first party special needs trust. And she had been in the system, the state system of Maryland, for many years. Had the daughter then passed away, this $400,000 basically would have gone to the state of Maryland versus her siblings, all because mom and dad, who were almost 80 years of age, thought, oh, we're doing a good job. We're leaving it to her trust. And she's never going to spend it down. There's hardly anything in that special needs trust now. The first party won 20, 30,000, and she doesn't spend that as it is. So it's very important to visit what type of trust you have, revisit, and make sure your planning is intact. I can't stress that enough. And there's other things that Megan only scratched the surface, trust me on this, because you can get into the details and into the weeds a lot as to, do you set these trusts up inside a will, or are they standalone? What are the benefits of one versus another? So we're simplifying this for this evening just to give you some terminology, but let's get into the one slide and it's only one slide on taxes. Because studies have shown people don't want to deal with taxes. They want their accountant to deal with it, but I merely want to make you aware of what the issue is. So, excuse me. You have two sides to this. You have estates and trust on the left, and you have single tax rates on the right. Now, you notice there in the bright bold yellow, it says trust marginal tax rates are compressed and can result in an undesirable outcome. Let me explain what this means. If you have a significant retirement account pre-tax and it ends up going into a special needs trust for a son, daughter, loved one, and there's a distribution out of it, say the distribution was $15,000. Tax rate at the federal level, this doesn't even get into anything state specific, depending on what state you're in. But a distribution that remains in that trust, and there's some other little provisions here, I'm not going to complicate it tonight, but you could be you could jeopardize that and be taxed at 37% at the federal level. And that's just 15 grand. And it doesn't take much to get a distribution of $15,000. I'm going to transfer this now over to what a person's single rate is, and $15,000 is only taxed at 12%. So how could this play out? Now, we were saying earlier that tax law changed recently again. One of the things that happened is with retirement accounts and inherited accounts to beneficiaries, and if they have a special need or a disability, they are actually treated differently versus someone who does not have a disability. It was Secure 2.0 signed the last week in December, totally changed everything again. And one of those things, if you're getting close to your 70s, you've heard about required minimum distributions out of your retirement account. For years, it used to be by April 1st of the year following you reaching the age of 70 and a half. And then it went to 72. And now this year it's age 73. They keep pushing it out. And it's actually getting bumped up to 75 years of age in the future, which people think, oh, this is all well and good. But there's some issues on the back end of this that are really important, and we're not getting into it tonight. The reason I put this slide up here is I want you to understand the importance that certain assets work better going into the trust versus other assets. Some assets would be better going to charity. Some assets are better going to other siblings. Maybe some assets are better going to other family members. It's so critical to look at the big picture. It's so critical that it could even affect your personal retirement and how you're spending your money in retirement. People don't think about that generally. So the only slide on tax tonight is just to know if you don't do it correctly, you could really be having a burden on your son or daughter's special needs trust if your planning is not done properly. That's the one thing I want you to remember. Now, let's talk a little bit about government benefits. Again, this is one of those areas that's so exciting. SSI, real quick, supplemental security income. You apply on the government website, ssa.gov/SSI. And I'm going to tell you right now, it is not the easiest process in the world, because my wife and I sat down and did it personally this week for our son. And I've seen it before with other folks, and I knew it was challenging because now they're going to request as much information on medical records, IEPs. And again, if you have children that are still in the system, or, even if they're, young adults or adults, you may have gone through this. How many of us have sat in on IEP meetings over the years? If you still have those documents, great. They're going to be good for whenever you apply for SSI. They can be helpful because it's a mean tested program. And obviously, prior to the age of 18, he wouldn't have applied for benefits because of the household income. But once he's now 18, he doesn't work. He's probably not going to work anytime soon. And I've heard countless times, if you're going to apply for SSI, do it as soon as you can, right after turning the age of 18. They're in the system then. Plus, there's some other benefits that in the event that, as a parent, one of us passes away, they can collect additional income on a deceased parent's Social Security benefits. There's also, but SSI is a means tested program. Also, I've heard recently that the Social Security Administration on processing all these 6 to 9 months out, maybe further. So get it into the system. As a side note, if you are looking to retire and you need to get into the ssa.gov, I will say this. I've done presentations just on Social Security. And a few years ago, the Atlanta office, I was down there, and the lady in charge of it, she said, encourage folks to set up a user ID and password on the ssa.gov website. It's one of the most frequent things that in today's society that gets hacked and your identity gets stolen when someone else creates a user ID and password in your name. So just as a little side note, once you do that, you'll be able to access all your statements and information online. But SSI is means tested. Individual have to keep under $2,000 in their checking account or savings or in their name after they apply. And but once you start collecting that, I'll give you an excellent example because of the age 18. If everything goes smoothly, and you can end up getting a denial and then have to reapply after an appeal. But right now, it's $800 to $900 roughly is what the SSI payment is. And real quickly, you could see how they could go over $2,000 a month in their checking account. And I'm sure Megan has done this and the office has done this. Then you can get into some creative planning as to, do you charge your kid rent? Well, indirectly, yeah, you can, so that you can keep their assets down and then maybe funnel that money into a third-party trust or other investment for them. I've seen people get real creative with buying life insurance with that money so that they're using the leverage to go over to that child's special needs trust in the future. There's all kinds of things that you can do to be creative, and it's all above board. SSDI is a disability insurance. Generally, you'd have to have a work record, but you could collect on that if you had a parent's work record as well. So there's some little nuances there, but that is not a means tested program. Medicaid jointly funded, it's the federal and state program. So like federal would be your federal and PA or federal Maryland, where I'm at right now. And it covers children, that have disability, blind. There's some other language right there. But the other thing most people see Medicaid for is when you turn, Medicare is when you turn 65, but Medicaid is also a program for low income, low assets. You see folks who'll try to get into that program if they're going into a nursing home, spending down assets. But you also see it in the event of an 18, 19-year-old where we could put him onto Medicaid so that he has that kind of health insurance for the rest of his life. Now, I want to talk about this briefly because I see this happen a lot. Parents, one that may have the means to cover the health insurance for their child. There's a level of pride that may come with that, and they're like, no, I'm not going to have my son or daughter do that. I get that. But on the flip side of it, what if mom and dad are no longer around? At least then they have some level of insurance or benefit. They're in the system for the rest of their life. I understand there's the pride thing, and I also understand that it's a benefit program that can be available. But when you make those decisions as a parent, we need to weigh it out just to make sure we're doing the right thing. Let's talk a little bit about ABLE accounts. Achieving a better life experience. Now, keep in mind, these are done at the state level. So you have a PA ABLE account, you have one for Maryland, you have one for Delaware. They all have their own state-specific programs. And you may look up and you're like, well, you're looking through the PA able and you're like, well, I kind of like that, but you can actually, if you're in Pennsylvania, if you really wanted to, you could buy the Virginia able account, or you could buy the Maryland one. Or since I'm in Maryland, and maybe if I wanted to buy the one in Ohio for my son, you don't have to buy the one specific to your state. There's underlying investments. They all have their own little rules. One of the things that's important now, a couple things. Sometimes an able account works out really well if the individual may just have a little bit of extra money that could disqualify them from SSI. You can put it over into the able account, and the able account has some really liberal ways that you can spend money, which is nice. Actually, it's a little bit more liberal than a first party trust as to how you can spend it. So we get pretty creative there, where money can go into the able account and allow us more capability of spending money on that child. So that's important, especially because if you notice there about 2/3 of the way down the screen, there's no in-kind support and maintenance penalty for assessed if there's payment for food and shelter out of the able account, where out of a first party trust that could be affected. Very important. So knowing you have these different components, first party, third party, maybe a pool trust, able account. Now the next question is, where do we spend the money from that so we don't get penalized? Where do we have money go into each account to minimize taxes? Where do we have money go so that maybe if the individual were to pass away, we know that it can still go to a remainder beneficiary or something like that, let's say one of their siblings. There's a lot of moving parts. Now, the other thing is, able account, generally across the country, they only have on average less than $10,000 in them. They're not designed generally to have large sums of money. As a matter of fact, if you get over $100,000, it's going to affect your SSI benefits. If you're getting to that kind of level of money, probably one of the other types of trust would have been more applicable. All right. So again, first party trust, as Megan said, I kind of like a Band-Aid sometimes after the fact, but if there was a settlement that came in, a large amount of money, you may end up having to go that route just so they can continue to apply for the benefits. But ideally, third party trust are phenomenal. So now the other thing with the able account, here's a little bit of, I like this screen because it just kind of tells you some of the expenses that you can spend out of an able account. And I'm not even touching on tonight some of the other rules that came out of the Secure 2.0 Act, because now if you have a 529 account, which is very similar to an able account, they're under like the same law, you can actually transfer those monies to Roth IRAs, pay the tax on it. So there's some extra little ways too that with an able account, you can fund them with money from a 529. Let's say you started funding a 529 for your son or daughter and you realize, oh, they're never going to use it because they may have some type of a disability, and you don't want to transfer it to another family member. You could transfer a 529 up to the $17,000 a year into an able account. So there's some extra little rules there. But this is the slide near the end of the presentation where I guarantee you, Megan and I would probably think, yeah, most of the people just got an earful of information. You got an earful about the different types of trust, first, third, hold. You know that taxes could be an issue if you don't plan correctly. We talked a little bit about able accounts, the picking trustees, guardians, custodians, and the wishes, as well as letter of intent or life care plan. Again, it's just terminology from one office to another, but it's all the same thing. And as Megan said, that's not an official legal document, but yet it's one of those things that when they're sitting down with the attorney and those people who are going to help care for your loved one when you're not around, that's an important document nonetheless. So at this point, you kind of feel disoriented, perplexed. and so forth. It kind of looks like a sign maybe that would have been in Europe during World War II. Everyone's going a different direction and they got switched around. So here's what you need. You need people that really know what's going on. You need the team that includes a special needs planning attorney. And you got Megan here and her law firm that she's affiliated with that does a phenomenal job. I've known Julie Steinbacher for many years and actually have done presentations with her as well out of the Williamsport office. You need a financial advisor that truly, lives, breathes this and understands some of the pitfalls more than anything that you could encounter and how to avoid them long term. You need an accountant because sometimes there's some credits that you may be available or have access to. That's super important. A care manager. This is a tough one too. There's some organizations out there that do provide some type of care manager. You see that more and more, especially on like elder side, but you're starting to see some of them migrate over and provide that type of care for people that are not elderly or going into the nursing homes and assisted livings and so forth. And I'm starting to see more of that. Actually had a conversation earlier this week as well with someone in Florida that's what they do. So super important. But here we are at the end, and actually Megan, do you want to put up, I know your phone number's there.
Sure.
Do you want to put your email in the chat box so folks can see it?
Sure, I can put my email in there. Yeah, and like Brian said, we gave a tremendous amount of information to you in the last 75 minutes, and yet we really only just scratched the surface of a lot of the things that we were talking about. And so while all of this is swirling through your mind, my top advice to you would be to reach out to me, to Brian, or to the other professional that you're already working with, to talk about your current situation, to figure out how can we whittle all of this information down that we covered tonight, focus on what is specific and relevant just to you, and then we can really hone in on just that information and put that plan in place. So let me go ahead and put my email in the chat.
And while you're putting your email in there, Megan, just so folks know, I do, even though my office is in Maryland, I do a significant amount of work in Pennsylvania. Actually, I grew up in Altoona and licensed in a lot of different states across the country. But if you're interested, feel free to reach out. The one thing that I do offer is a initial consultation, usually about a half hour, 45 minutes, and I don't charge you for that. I think it's super important, one, that you have a comfort level and say, hey, here's what my situation is. I want to make sure that we can provide a value to you. And, in that half hour, 45 minutes, we can have a conversation. And at the end of it, we'll look up and say, yeah, I think we can provide a value. And does it make sense for us to work together in the future? Or does it make sense that maybe I'm not the right fit for what you're looking for? And the nice thing with Megan and, the law firm there, I work with the attorneys. I'll sit in on the meeting to make sure everything is what we're doing on the financial is tied into the legal. So, but if you're interested, feel free to reach out, shoot me an email, give me a call, and just say, hey, I was on the presentation, Wednesday night, and be happy to meet with you either in person or via Zoom. Megan, has the office in State College. They have the office in Williamsport. Actually, for those of you that are up that way, Kyle was mentioning prior to getting on here, I'm in Williamsport periodically because my in-laws are from up that way. So, and be happy to work with, I think it's Washington Street, where
Washington Boulevard. Yep.
Washington Boulevard. Yeah. So I'm familiar with Street Boulevard, but yeah, happy that we could probably even use Julie's office up there if we needed to meet in person. So very flexible that way. And State College as well.
Yep. Same thing down here. I work out of our State College office, but I also do a lot in Williamsport as well, where I'm available to meet in person, over the phone via Zoom, and our office also offers a free 1-hour initial consultation for all attendees of our webinars. So you really have nothing to lose, just to sit down and talk to see if there's anything that we can do to help you. Great. Well, thank you so much, Kyle, for organizing this seminar. Thank you, Brian, for joining us and providing your wealth of knowledge that you have. And thank you, everyone, who joined us tonight and took time out of your evening.
Thank you.